Could you please state your name for the court?
Jesse Rogers.
Thank you.
Your Honor, thank you. Good afternoon. Today, the time set for the preliminary exam in this matter. I had an opportunity over the weekend to review the reports. I spoke to Mr. Warren Green. There is a handful of documentations that are alluded to within the report that neither party simply has. I went through it and I'm not sure. It doesn't look like it ever happened. I reached out to the records department of the sheriff's office as well as the OIC, who now is at a different police department. And they're looking into it, but I've not received those documents as of this time. I am unable to adequately perform this exam.
This is a huge problem already. In court, missing evidence isn't a small mistake. It's the foundation of a case collapsing. No documents means no fair defense, and no fair defense means no trial should move forward. Simple as that.
And so I'm going to respectfully ask for.
Why weren't I don't understand.
And Your Honor, our position is I'm asking for a dismissal. When we set this examination, I set it with the understanding that we had everything the people had. And I believe that to be true today. I'm asking for a dismissal because I don't think it's the case that discovery is incomplete. I think the people are simply missing evidence they need to.
Translation: the defense is saying, you don't actually have proof, you just have accusations. And in the legal world, that difference is everything. So quick question for you watching. Should someone face charges if the evidence might not even exist?
Move forward with this case.
Well, which is it? I mean, there are things referred to. What I got out of that was there are things referred to in the report. Do we know whether they exist or don't exist? And if they exist, why haven't they been given to the defense prior to now, and certainly prior to the time that this examination was set?
So the report refers to a couple of different items, i.e. a spreadsheet from the University of Michigan Credit Union, as well as a phone call. And it says that the phone call was uploaded to evidence.com. I go to evidence.com, I don't have it. It's just not there. The spreadsheet, there's something that might be the spreadsheet, but I'm not sure if it is the spreadsheet. So there's things that are in the report that I don't feel comfortable. The phone call I just don't have. The spreadsheet maybe is there. I'm not 100% sure that that's a spreadsheet. It doesn't look like a spreadsheet, but
I don't know what that means. Is it a spreadsheet or isn't it? I mean, if it refers to a particular document, I think you'd be able to try to figure out what it is.
I think if it was copied and pasted from Excel and then into a Word document, it would have just been a formatting error that I wouldn't necessarily be able to make heads or tails of.
And Your Honor, what the defense is in possession of is what purports to be the complainant's banking app records. Those are contained in what is a spreadsheet, and that was produced. What I think the people are missing is Verizon records that are mentioned in the report, but were not produced, are not in the people or the prosecutor's office possession, and certainly haven't been turned over to the defense. I believe we have everything they have.
Why are those records as a proffer necessary for the exam?
The way that I believe that I can prove the case is to show the connection between the defendant and her use of an IP address that comes back to her phone number. And I don't have any of those.
This is the moment the case starts falling apart in real time. The prosecutor admits they can't connect the defendant to the crime. That's like trying to bake a cake without flour. You can try, but it's not going to work.
Documentation.
Then how did it get charged?
It's a good question, Your Honor.
Oh, yes, it's a good question. And I don't know whether she's guilty, not guilty. She's presumed to be at this point in time, but she's been going through this process and get to the date of a preliminary examination. Her first step And you're telling me you can't show the case and that there's something out there that you don't have, never had, that would link her to this case. So why is she? Going to grant the defendant's motion. This case is dismissed.
Case dismissed, but without prejudice, meaning prosecutors can try again later. That's legal language for, you're free today, but this story might not be over. Would you feel relieved or still nervous?
It is without prejudice. So, ma'am, you need to understand that they can bring the case back, but I'm going to give you fair warning. You bring it back, you better be ready to go. You better have everything that would tie this defendant to this case, or there are really going to be problems. Thank you.
Thanks, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Dylan Chapman.
Your Honor, Alexis Plumey, Assistant Public Defender, appearing with and on behalf of Mr. Chapman. Mr. Chapman, could you state your name for the record?
Dylan Chapman.
Thank you.
And Your Honor, today's the date time set for preliminary examination. I understand there is a bond violation. However, also at this time, people are unable to proceed as to counts 1, 2, 3, 4, and 5, and would ask for counts 6 and 7 to be remanded down to district court.
So you're unable to proceed on 1 through 5.
Correct.
And would like 6 and 7 down. Got it.
Correct.
Counsel, you're moving to dismiss counts 1 through 5.
Yes, Your Honor.
Continue to defendant's not guilty plea as to count 6 and 7. Set this matter for pretrial.
January 29th at 10:30 for Judge Simpson.
That date might change. There's an in custody name. We'll see, but you got the 29th right now, correct?
Yeah.
Got it. What time? 9?
10:30.
10:30. Before Judge Fresh Hour. As to the bond violation.
Yes, Your Honor, I have had an opportunity to discuss the violation with my client. He has provided me with an explanation that he feels comfortable with me sharing with the court. This was reported as a hit and run accident. Mr. Chapman states that the complainant in this case was using his car, which she had reached out to his mother and asked if she could borrow because hers was either broken or not able to drive in the snow. He states his mother gave her the keys to the car and allowed her to use it. And then Mr. Chapman states that at some point that night, his mother called him and let him know that the complainant had been involved in a hit and run accident with his car. He tells me that he did go to the scene of the accident to try to check on his vehicle, and that at that point, the complainant was not actually present. It's unclear to me in the report at what point in time the police made contact with the complainant because it was a hit and run accident. I'm not sure if contact was made at the scene or later on, and there's not a whole lot of detail there.
Now we jump to a new defendant, new problem, bond violations. A personal bond is based on trust. Once that trust cracks, judges stop being friendly and start thinking about handcuffs.
So Mr. Chapman is asking that the court consider keeping his personal recognizance bond in place, given that explanation, and potentially setting for a pretrial and bond violation combination in front of Judge Fresh Hour so that if there is more detail that needs to be provided, Judge Fresh Hour could consider that.
Your Honor, at this point, I have concerns given the nature of that bond violation with his wallet, his other property being in the car. He's not there. I would have concerns about contact with the victim, being there with her, especially given the nature of the charges. So at this point, I would ask that he be remanded on the bond violation.
Your Honor, again, the only thing I will add is that Mr. Chapman explained to me that his wallet and other items were in the car when his mother provided the car to the complainant. So again, he's just asking that the court
Really?
consider. Yes, Your
That
Honor.
his wallet, ID, and all of his everything is still in his car.
Yes, Your Honor.
Clean sheet.
My understanding is that the car was supposed to be returned to his mother soon thereafter, and that Mr. Chapman said it was okay to leave his wallet in that in case the complainant needed to use his debit or credit cards.
So how close was he when this vehicle crashed? Because they have him one driveway over.
Yes, so Your Honor, he states he did go to the scene of the accident after his mother told him that there was a hit and run crash to check on his vehicle. However, it's unclear to me in the report, and based on what Mr. Chapman is telling me, at that point in time, the accident had already happened and the complainant was no longer there, and he was just going to check on his car. So again, I'm not sure because it's unclear in the report.
How do
whether
I know the complainant's not there if she had the car? From this defendant?
So the complainant's not at the scene of the accident.
Yeah.
Right. We don't know. And I'm saying that it's unclear to me when contact was made with the complainant, at what point in time.
I hear you, but none of that makes any sense to me because it almost seems like he's with the complainant. The vehicle crashes, she leaves, and he's still there. That's why the only thing that makes sense as to why his wallet, ID, all of that stuff is still there because
This is where the judge mentally connects the dots. Wallet in the car, defendant nearby, victim involved. The story doesn't add up, and when stories don't add up in court, freedom disappears fast. So what do you think? Unlucky coincidence or caught in a lie?
he was in that vehicle when it crashed.
And that is not the explanation that he is providing.
I get that.
Yeah.
But none of the other part makes sense. I'm not. Anything else?
No, Your Honor.
I think when I look at everything, that the defendant was having contact with the victim in violation of the bond conditions in this case, and based upon what was said, at this time, I will move his pretrial date up to January 15th, 2026. That's still at 10:30.
Yeah.
January 15th, 10:30. But at this time, the court's going to believe that there's enough evidence and to indicate that there's been a bond violation.